What happens when your colleague or boss crosses the line? Welcome to Court Helicopters News, and on today's Legal Explainer, we shall be talking about sexual harassment in the workplace. Imagine this. One morning, you wake up to a text from your CEO asking, being a link to an article saying what happens when you stop having sex. Then it progresses, a touch here and there, an invitation and solicitation for a kiss, and eventually a rape. This is what happened in the case of RAO versus OL and Power IT Solutions. RAO was employed to work at Power IT Solution, where she was reporting directly to OL, who was the CEO and her direct manager. And consequently, OL started to solicit for sex and crossed boundaries with OL. And when RAO reported this matter to the COO and HR manager, she was put on immediate 28 days leave, followed by what the company termed as investigations. And when she returned back to work, she was notified that the HR had not found any legal implication against the CEO, and that the investigations had been completed. Subsequently, RAO proceeded to request for sick leave, and after a day of sick leave, she was summoned back to work and asked to continue with work. She made the decision to resign from that workplace and subsequently filed a case in court for constructive dismissal. When Justice Ruto was determining this case and looking at the circumstances, she noted that on a balance of probability, it would be strange for a colleague or a boss to send you a text asking you, why are you ghosting me after a one-night stand? The court noted that while OL said that there had been no sexual relations between the two of them, the fact that he had sent a single text to this employee asking her why she was ghosting him and whether his sexual game was that abysmal was enough proof to show that there had been unwarranted sexual encounter with this employee. And in the end, the court awarded this employee 10 months worth of compensatory damages amounting to 1.32 million. So what is sexual harassment in a workplace? Sexual harassment is where a colleague or another employee in the workspace solicits directly or indirectly for sex with another employee. It could be in the form of pictures. It could be in the form of sending sexual contact, or it could even be sexual contact with another employee. The law under the Employment Act in its Section 6 requires that any employer who has 20 or more employees has to have in place a sexual harassment policy. And this policy has to inform employees, one, that they are guaranteed to work in a workplace where they are free from sexual harassment. Secondly, that the employer shall put in place every mechanisms to ensure that any reports of sexual harassment are addressed and are resolved in accordance with the law. Thirdly, every employer is required to put disciplinary mechanisms and protection mechanisms for any employee who alleges to have been sexually harassed in the workplace. Thank you very much. My name is Wanjiku Waithera. Follow more for other legal explainers.